Alright. This first episode is going to kick off a series on Water Rights 101. We're going to start with all the major dates throughout water law history and lay out the groundwork for what defines the Washington water right landscape. It's clearly a little bit chilly out here, so I'd vote we get some coffee or tea going and let's get code breaking. Alright, hope you also have some caffeine, because we're about to dig deep. Let's get into some basics of water rights. There's two things to keep in mind before we get into the nitty-gritty. One, major dates matter. In the state of Washington, we have a system based on seniority, so knowing exactly when things occur and kick in and start affecting more junior water rights or users is really important to know. So we're going to need to do a little bit of memorization if you can harken back to your elementary school history days. The second point I want to emphasize is that water rights have a bit of a life cycle, and different parts of the statutes and water code affect the water right in different ways, depending on what part of the life cycle it's in. We're not going to dig into that too much right now, but keep that in mind. It's good to know. I'm also going to throw one sub-point out there. There's a lot of really ridiculous jargon in the water rights world. I'm going to do my best, but let me know if I miss anything. So where else to start? But what is a water right? Well, a water right is a legal authorization to use a reasonable amount of public water for a specific beneficial purpose. You got those 2 points? Reasonable, beneficial. It is a use-based, or you'll hear the term usufructory, vested property right for the most part. So why are water rights even required? Can't we all just use the water that we see flowing by our city, town, front door, whatever? Well, water rights are required by law to ensure that there's proper allocation and management of Washington's water resources. All of our state's water are public resources, and their use has to return the maximum benefit to the public. Water rights establish very specific priority dates. These priority dates are really great tools to protect more senior water rights or in-stream flows in any times where there's water shortage. There's a very strong system of, I was here first. Alright, so let's hit the first one of my key dates. One, let's look at the pre-state and territorial times. So we're talking 1889 and earlier in Washington state. So during this period, we're still rocking off English common law for the most part. Water is a natural resource held in common for the public good. That's a common sentiment. It's not owned by anyone, and individuals have the right to use it during this period of time. You hear a lot about riparian or bank-side water rights during this time, and these emerge by some virtue of property ownership if you're next to a lake or a river or a stream. This is a really common philosophy on the East Coast where water is more prevalent. Each riparian user had an equal right to the water at this point in time. Reasonable use had to be made. You couldn't entirely cut off your downstream neighbors just because you wanted to. Riparian users were entitled to some protections, even against appropriations that occurred after their priority date or their original date of claim was established. All right, I have one more key date for you within this 1889 period of time. In 1891, we see a formal establishment of the prior appropriation doctrine. The doctrine states that the right to use water in any water body may be acquired by appropriation, and as between appropriations, the first in time is the first in right. If you're going to get a cool water right tattoo, that would probably be it. That phrase is going to come up again and again. The first in time is the first in right. Water users at this time were required to post a notice about their intent to use water on a tree near their diversion and record the notice at a county courthouse. This led to some chaos during the early settlement where there's notices all over trees. I don't see a lot of trees in eastern Washington, so that probably led to some confusion. And folks are, destroying other folks' diversions when their water supplies get a little bit low. This drives tensions pretty high. Okay, so after 1891, we have the second major date that we need to pay attention to in this sequence. In 1917, after Washington is declared a state, we have the first bit of legislation specifically detailing how surface water is going to be managed and appropriated throughout the state. The Revised Code of Washington, or RCWs, are the key bit of code we want to look at here, and 9003 is the reference that you want to live, breathe, and die by. At this point, we see the formalization of all waters of the state belonging to the public, subject to existing rights. It's all based on this prior appropriation doctrine that we just talked about. First in time is first in right. RCW 9003 establishes a permit system for appropriating surface water. The other key point of RCW 9003 is that it lays out a system for adjudicating vested water rights. Adjudication is a really important mechanism in the state of Washington. This is where the judicial system comes into a specific basin or sub-basin and looks at all the water rights and makes an actual determination as to their extent and validity, or how much has constantly been in use since the water right was issued. The legislature, as part of 9003, also mandated that the state administer all water resources. So we get the predecessor to the Department of Ecology at this time, the Department of Hydraulics. So what does this mean? This means that we have new paper coming out. And we're going to start with the first piece of that, which would be water right applications. So what is a water right application? Well, an application is a dream. It's an expression of an applicant's intent to develop a project. It has a goal, it's a proposal. It lays out some basic project information like quantities, location, purpose. There's a priority date that's linked to the submission date of that specific application. And historically, the fee's been pretty modest. So it was easy for applications to be filed on very speculative projects. To actually begin developing your dream, you need your application to move into the permit stage. What is a permit exactly? Well, a permit is the ability to appropriate water. It's an inchoate or unperfected or undeveloped water right. When a permit is first issued, it's basically incomplete. You need to show good due diligence in developing that permit toward the listed quantities on the actual water right. Basically, a permit is permission to go build what you want in your application. You need to show reasonable progress and due diligence, but these permits are not subject to relinquishment. Relinquishment is a concept where if you're not actively using your water right, you lose it. There's a little bit of grace given to permits because they know that you are actively working toward a project and a dream. When your dream is constructed and you have all the infrastructure in place, you are required to file a completion of construction form. And when you either hit the given date listed on your permit or you're ready to go and you have all of your water that you think you're going to need for your project in full use, you're required to submit a proof of appropriation that lists the attributes that you've managed to perfect on your water right. It is fairly common for the dreams on an application to be downsized a bit when the permit is ready to be proved out. Oftentimes folks are fairly optimistic in the amount of water they think they're going to need to use. After the permit stage, there is a certificate stage of a water right. So when a permit is ready to go and that completion of construction is filed and that proof of appropriation is filed, in a normal world, ecology would come out and do a nice field investigation on that water right. They're going to verify that everything you filed in that proof of appropriation is accurate. Once that investigation is done, they will issue you a certificate, which is your real piece of paper linked to your property that represents a vested water right. It's basically an award to say that you beneficially used your water for the amount of water permitted at the location identified for the intended purpose. And you'd think at that point that you would be done. But in the state of Washington, there's quite a few requirements for certificate holders. You need to be protecting your water right from relinquishment, which we're definitely going to talk about in an entire video series. You most likely need to be metering your water use and potentially reporting it to the Department of Ecology annually. And finally, if the way you're using your water needs to change in any way, either you have, an example would be redeveloped your orchard to put in some housing units, that purpose of use on your water right is going to need to change to fit the new use that you would like to put that water to. That requires an entire change process, which is again going to open up the water right to ecology scrutiny. So basically I'm saying, you're not done, even though you think you're done. Now that we've talked a little bit about water right life cycle, let's go back to those key dates. So we talked a bit about 1889 and the prior appropriation doctrine. We also talked about 1917 and RCW 9003, our favorite bit of the Surface Water Code. Well, almost 30 years goes by and wells become a lot more common in Washington state. And so we start getting some pressure at the legislative level to look at legislating groundwater. Other Western states did not choose to go this path. But in 1945, the Washington state legislature passes the Groundwater Code. What this basically does is extends the 1917 Surface Water Code to groundwater. There's a couple small differences in the code, but it does create a permit system that allows for permitted uses of groundwater. There's also a really neat subpart of this code that allows for exempted withdrawals of small amounts of domestic and industrial water. It allows irrigation of up to half an acre of lawn and unlimited stock watering. The final key bit I would flag about this 1945 Groundwater Code is that it set up a declaration period for anyone that already had vested uses prior to 1945. Folks could come in and submit a document saying, I have been using this and I would like an earlier priority date than 1945. The key RCW you want to remember for groundwater is 9044. Give it a read sometime. It's a great one. Top 5, definitely. So you'd think we'd be good after we get the surface water and the groundwater code established, but there was a lot of uncertainty at the time. A lot of junior users had these nice certificates by following the new permit systems, but most senior water users still just had county declarations and probably really rotted postings to trees trying to explain what their diversions were going to be. This lent a lot of uncertainty about how water resources were going to be managed. In some cases, actual demand was far less than what a couple pieces of paper said. So, in 1967, fourth key date, the Water Rate Claim Registration Act was established. This basically established a water rate claim registry. This was supposed to cover all vested water uses that were not previously required to be documented. The RCW we want to look at here is RCW 9014, and you can go there for additional details, but the hot spots here are that it was $2 and required a single page to be filed. There were multiple claim registries. The first began in 1969, the second was 1974, and approximately 170,000 claims were filed during this period. There was also some tension on ecology to reopen the claim registry a little later, and it reopened in 1985 and 1997. So, what is a claim? We talked a little bit about how there are all these checks on applications and permits where folks are coming out and investigating your actual water uses. But that wasn't a requirement for filing a water rate claim. So if I file a claim, do I actually have a real water rate? The answer there is not necessarily. A lot of folks mistake claims as water rates, but a water rate is a legal authorization to use water. A water rate claim is only a statement that the claimant believed they had a vested water rate. The extent and validity, that's a very key term in water rates, of a claim can only be tentatively determined by the Department of Ecology. Extent and validity refers to how much you have perfected and protected your water rate. An extent and validity investigation will involve looking back at water use and looking for any instances where water may have been relinquished due to non-use or abandoned due to taking apart the infrastructure that you needed to actually withdraw or divert that water rate. Tentative determination is also a little bit of a tricky but key concept in Washington Water Code. Only the judicial system can perform a true extent and validity on a water rate through the adjudication process that we discussed earlier. The Department of Ecology, the executive branch of all of this, are allowed to tentatively determine an extent of validity. There are several points during a water rate permitting cycle where they're allowed to touch the water rate and make an assertion about what they think is still valid in that water rate. Claims don't necessarily get that touch. All final determinations on whether your claim is a true water rate or not are reserved for these adjudications that occur. Adjudications are pretty rare. The last one that we had in the state of Washington involved some of the Yakima subbasin, and it only looked at surface water rates, and it took over 50 years. So we're not moving and grooving through the different subbasins in the state. It's very likely that if you hold a water rate claim, it may not be exposed to a tentative extent of validity unless you take it in front of ecology to ask for a water rate change. That feels like enough for one video, maybe too much. I can't think of a better cliffhanger than adjudications, though. We're going to end it there. In the next video, we're going to talk a little bit more about relinquishment and how that occurs. We're going to talk about abandonment and how it's slightly different than relinquishment. And we're going to talk about lack of diligence in developing a permit. My name's Taylor Dayton. This has been the Water Codebreaker. I hope this has been a good resource to get some basics on Washington State water rates. If you have any questions, I've got an email address down in the description of this video. Feel free to fire off any questions. Thanks for sticking with me.